All rise. Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning.
I am Judge Ferruia, and to my right is Judge Catani. To my left is Judge McMurdy, and we are met here for oral argument in our case number IC22-0017, McDermott versus BALFOUR and STARR Insurance. And as you may know, we record and live stream these proceedings, so please give your name prior to beginning your presentation. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time, so if you would like to reserve any time for rebuttal, you may do so, but please bear in mind the time on the podium is inclusive of that time for rebuttal. Please keep in mind that we have read the briefing, we have studied the record, and we have discussed this case in conference. And with that, you may proceed.
May it please the court. My name is Tom Wilmer. I'm here on behalf of Mr. McDermott. The question before this court really boils down to procedure. And that question is, what is supposed to happen at the request for review stage? In this matter, Judge Sheo, who's an excellent judge, took the testimony and issued a decision. After that, apparently he left the commission. That was news to me when I got Judge Bodie's decision upon review. And if you read Judge Bodie's decision upon review, she essentially says, my hands are tied, I can't perform a de novo review of questions of fact, and I can't revisit credibility on a paper review. With respect to the latter, that's accurate. She can't do that. But the question of what she can do in terms of a decision upon review is controlled by the statutes. 943 says she can't do that. 943 says it has to be the presiding judge that revisits.
So what are you suggesting happens when a judge dies after issuing a decision?
It's simple. The chief ALJ has to vacate that decision and reassign it to a new judge.
But why? Why does that make sense in the context? Do we really expect the legislature to spell out, in every other context, if a judge dies, we put in a replacement judge? Why does it make sense to say, oh, we have to vacate everything that happened before this judge died? If there's a final ruling, they issued a decision. I get that the points you're making about needing to be able to review, but assuming we say they have to do a de novo review of the record, the next one, why is it a problem to substitute in a new judge?
Well, because at the request for review stage, that gives the litigant the chance to say to the judge, you made a mistake. You need to revisit the evidence. You need to revisit your thought process.
But don't you have a chance to do that with a new judge?
Sure.
But I noticed the case that everybody cites that's talking about that defines presiding judge to be the one that presided over the hearing. That was one where the petitioner wanted a different judge, wanted the chief or someone else to do the review.
Right.
And they said no, presumably because you think there's some benefit in having a new set of eyes look at it. And they said no, it's the presiding. But if the presiding's not there, why does it necessarily happen?
This happens a lot in workers' compensation proceedings, but not with respect to after a decision has been issued. We take hearings all the time where a substitute ALJ shows up and says, I'm here, Judge so-and-so is sick, or Judge so-and-so couldn't do it. Is it okay if I take this testimony? Typically with doctors. Always, the litigants say, that's fine, unless you've got some particular issue with an expert. So, in fact...
Well, isn't that, I mean, I've seen those cases, but isn't that the reason for that is because these are all video recorded, so that the judge that's actually going to render the decision can simply go back and watch the testimony.
That's right.
Okay, so in this context, when Judge Bodie got it, if we say, no, she has to do de novo review because the other judge was not available, can't she go back and look at the the video and read the record and make her own determination?
I suppose that's true. That's what happens when we have substituted, but there's a distinction between 942 and 942.
Well, I'm not sure there is, but let's go back to my question. So if she can go back and do that de novo, are we limited in this case to simply saying whether or not her statements that she was bound by the factual determinations would be a violation?
Well, no, she says I can't review it de novo, period.
Okay, well, there you have it. So the same thing. So if she says I cannot review this de novo, then the error occurred when she took the case and said I'm not going to review it de novo.
I agree with you. That's where the error is. You know,
No, but are you saying the error is you can never have a substitute judge? Someone died.
Not at the decision upon review stage. The statute clearly says that. It has to be the presiding judge.
But the statute doesn't contemplate somebody died. I mean, can't we just read some common sense and do it? If somebody died, we have to have someone else do it.
942 contemplates that.
But it contemplates it in the context of, it's kind of odd to substitute in midway through a hearing. It's okay, and in that context, we can have somebody else come in. That one seems unusual, and that's why you would provide for it. But to provide for what happens if somebody dies who's issued a ruling, it seems like we can just read some common sense into that and say, yeah, you'd have to have someone else take their place.
Right, but under that circumstance, that judge has to issue a new decision. They can't issue a decision upon review. And the statute clearly says that. It has to be the presiding judge. When that happens, let's say, for example, we've taken 10 hearings, and Judge so-and-so issues a decision, and then dies or leaves the commission, or what have you. Under that circumstance, what is most workable and what typically would happen in the setting of a substitute judge before a decision is, judge says, hey, Judge so-and-so is dead, I'm going to vacate this decision, I'm going to review the record, and if someone has a particular need for me to take a hearing to observe a witness, because credibility is at issue, I'll do that. And that's what happens.
But then you get an extra layer of review after that. You're saying you essentially get that review, and now you get another review after that.
Yeah, that's true.
And the statute doesn't say, and if the presiding judge is not there, you have to vacate everything and do a new trial. It seems like we're reading more into the omission than may be warranted.
Like I said, there's a huge distinction between 942 and 943. 942 clearly says the chief ALJ may substitute someone else before the decision is rendered. 943 says the presiding judge shall. Shall means must.
But that's assuming they're still alive. I mean, we don't need to read something into it. If they're not there, we all agree if they're there and available, they should do it. But how is this different than, for example, just a motion to reconsider in a typical civil case? We would expect the same judge to reconsider his or her own ruling.
I agree with you, but in motion to reconsider, even before this court, the litigant asks the judge, you need to revisit what you did here. You need to revisit your thought process. You got the law wrong. Here's facts over here you didn't consider. That's what you get. That's what you get at the request for review stage. My client didn't get that. My client got Judge Bodie saying, sorry, I can't review this.
Okay, but I agree that that's a different with her saying that she can't review that. But assume she didn't say that. And assume she said, I'm going to do a de novo review. I'm going to watch the videotapes and do it. Do you still have a problem with having a substitute judge proceed in that manner?
You have to, assuming that could be done, assuming the statute would permit that, or that could be read in, you still have to get the litigant the chance to say, hey, judge, there's a credibility question here. You need to take this witness testimony and observe them. You can't do that on a cold record. And we don't have...
Except it's not really a cold record. I mean, these are video recordings.
We don't have video. All we get is audio. I don't know if you guys get video, but what we get...
We get transcript.
You get a written transcript. Right, so what we...
We have a cold record.
Right, but the ALJ only has an audio recording. The ALJ is not there to observe a witness who's fidgeting or who's not making eye contact.
Were there really credibility determinations in this? I mean, the original ALJ, though, as I understand the record, said, yeah, these two witnesses were credible.
Right.
But that isn't really, I didn't find there was a dispute between what everybody said.
Well, there's a dispute in the sense of what my client told him. He says, I told him how I was hurt. And that in my opening brief, I spelled it out. There's a lot of different evidence to
I thought your client said, I told him I wasn't really sure.
No, that's not. He testified that he told him specifically what happened. And so, and Judge Sheo didn't make a credibility decision or finding relative to what my client said. He just said, I believe these guys. He didn't forthwith report it. And in my opening brief,
If we take just what the other employees said, why isn't that enough?
because there is a provision to excuse failure to
I mean,
forthwith.
we're saying, why isn't that enough to show that it was forthwith reporting? The other employers said he wasn't sure when it happened. They didn't say, no, he denied hurting himself at work. That if we were to agree with you there, are you still concerned that that under no circumstances can you have someone fill in for a deceased ALJ?
I think, assuming you're not going to just adhere to the statutes, plain language, it says presiding judge, if it's a question about science, for example, and that's in Kruger. You know, the judge cites Kruger to say, I can't do a de novo review. But if you read Kruger, there wasn't a dispute of fact. In Kruger, you have two doctors saying, we don't think the AMA guides, even though the AMA guides say 5%, we don't think we should follow that. So that gets all the way up to the Court of Appeal, the Supreme Court, and the court says, you're right, you don't have to do that. So that was a pure legal question. There was no argument about a finding of fact in Kruger. And, you know, I went back and I read Adams, which is the case that Judge Bodie cited saying I'm bound on credibility findings. And if you look in Adams, they cite a case called Brooks. And that was a case where a substitute ALJ basically took what sounds like most of the evidence, and then the original ALJ issues a decision saying this is a compensable claim. The carrier in that case says, no, on review, you need to conduct a new hearing to take the testimony of a certain witness because credibility is at issue here. And the judge did that. The judge came back and reversed the decision, saying it's now non-compensable. So the point that I have tried to make to you is that a request for review is where you get to say to the judge, you need to revisit your thinking on this. You need to revisit the evidence on whether this person, slipped at work. So I didn't get that here. My client didn't get the chance for the judge who decided the decision to revisit his thought process.
But isn't that just because the judge who did it said, I'm just bound by credibility determinations?
You mean Judge Bodie?
Judge Bodie.
Right.
Right, but it's not the fact that it was a substitute, it was how the substitute proceeded.
Right. I mean, that's accurate in the sense that, my complaint is on a request for review, you're there to persuade the judge that they made a mistake. You got the law wrong, you got the facts wrong, you missed an excuse over here. That's the whole purpose of the request for review stage. It's in fact, I looked at the there's an administrative code, and it talks about that as far as the review. It says that whatever agency it is supposed to create a rule about review that closely follows Rule 59 of the Arizona Rules of Civil Procedure. That's the provision to say, I need a new trial. You made a mistake on a jury instruction. There's a problem with the juror. There's new evidence. So the request for review stage...
A Rule 59 motion could be ruled on by a different judge. If a judge died, I assume a different judge could do that. Is that fair?
I'm not sure about that. I'm not sure how to answer that question.
So in the middle of a trial, I'm just puzzled. I mean, we had...
But a judge in a Superior Court case, unless it's a bench trial, is not going to be making decisions of...
But let's say it's a bench trial. Bench trial, he's made some decisions.
Then you get back to the same problem you have here.
But
You didn't witness the...
I'm not aware, and actually was looking, I'm not aware of any case that would say a Superior Court judge, a new Superior Court judge can't be, rule on such a motion.
Well,
My concern would be, for this case, is that in the Rule 59 context, the judge who actually rules on it is not bound by, he or she is reviewing it de novo,
right, but
based on the arguments.
but-
In this case, Judge Bodie did not review this de novo.
Right.
So it is different between the two situations, correct?
Yeah, it's different. I mean, I suppose if the court wants to craft a decision that says that, in the event there's a lack of dispute or conflict relative to facts, a reviewing ALJ can review the decision to see if it's legally accurate. Or, like I said, in the case of Kruger, that was a pure legal question. Are we stuck with the AMA guides? And so there was it wouldn't have made a difference as to what judge reviewed it. That was a question of law, not a question of fact.
But so you're saying the statutory language notwithstanding, we could hold that?
No, I'm not saying that. The statute says what it says. It is plain English. And there's a distinction between 942 and 943.
Right, but you do agree, it's a different context in that you're actually allowing something that you would think would be, why would you want to permit somebody who didn't hear the witnesses actually make that ruling? And they're providing for that.
In my view, you shouldn't. You shouldn't.
Right.
But
it's nonsensical from my perspective to say it's okay, but we're gonna impose a requirement on the legislature to spell out if the judge dies, you don't get you have to have an entirely new hearing. You have to vacate the ruling, and you essentially get a second appeal that no one else gets because they died.
That's exactly what would happen. But you're talking about a situation that is super, super rare.
Is it? I mean, I see
is.
ALJs resign all the time.
Not after they've issued a decision. I've been doing this for 32 years. Casey's got me beat by a couple of years. Yes, there are cases on the books where it happened, but no one complained about it. Kruger's the perfect example.
But is that because it's common sense? Somebody died, somebody retires, and they're not available. We have to. We don't set everything aside. We had something similar in criminal cases years ago, where there was a provision that said you have to have the same judge handle a PCR, the post-conviction relief proceedings that presided, but they of course say unless the person is not available, and that it's just kind of common sense. But we're saying that because it's not in there, we can't apply common sense.
Well, it's hard to answer that question. And like I said, my point or my complaint is that I thought Judge Sheo, great judge, you'd love to have him, smart guy, reasonable guy, intuitive guy. Judge Shea, you made a mistake. You missed this evidence over here. You should reconsider that. I didn't get that.
But wouldn't you get it if you got to present it to another person that say, he's a smart guy, but he'd completely missed this, and here's why? Isn't that even better for your client to have a new set of eyes, make a de novo review?
Depends on the judge you get, really.
But that goes back to your complaint is you didn't get de novo review with the new judge.
That's right. I didn't. And like I said, that's why I analogize this to motion for a new trial, motion for reconsideration in Superior Court. Judge, you need to review this. You need to reconsider what you did. You made a mistake, and here's why.
We do have motions to reconsider that are handled by new judges.
Well, that may be true, but the rules probably permit that. And here they
but
don't.
That's why I'm just trying to get at whether you're really pushing that it absolutely cannot be a different person, or just that it has to be someone that engages in a legitimate de novo review.
All I can tell you is the statute says what it says. And there's a huge...
But you would, see, this is, you need to think about what we're saying. We're saying, even if we disagree with you, you're saying, I still win because I didn't get de novo review.
Right. I didn't get de novo review, which I'm entitled to. I'm entitled to have the judge who decided the case revisit their thought process, revisit the evidence, revisit questions about the law.
So your argument is, I think I should have had it vacated, but even if I'm wrong on that point, I still win because I didn't get a de novo review.
Right. That's exactly right. I didn't get de novo review. And that's why there's a distinction between the two statutes. One says before a decision, you can substitute a judge, they can make the decision. If the judge makes an error, you got request for review to the litigant.
But you're saying more than de novo review. If you're saying it has to be, absolutely has to be the same one, I get to go back a step, I get a review by this one, and then I still get another review. So you're saying more than I was entitled to de novo review. If you're saying it has to be by that same judge.
That's what the statute says.
Okay.
I mean, it's clear, and I've got 15 seconds left for my rebuttal, so I'm going to keep that just in case. Thank you.
Thank you, Mr. Wilmer. Mr. Kirk.
May it please the court, counsel, my name is Casey Kurth. I represent the respondent employer and the respondent carrier. McDermott had his day in court. McDermott he received his statutory right to a request for review, and in my view, McDermott is using the opportunity of Shale's retirement to obtain a chance to relitigate.
Did Judge Bodie give a de novo review to the claims raised in the motion for review?
I'm sorry, I did not.
Did Judge Bodie give a de novo review?
No, she did not.
And so, to that extent, he didn't get what every litigant wants when they file either a motion for reconsideration or a motion for new trial. And that's an adequate consideration of the claims raised in the motion, right?
Well, I don't believe you're entitled to a de novo review, and maybe a de novo review. On review, 23943 clearly states that they are going to review the record and the memorandums. It doesn't say we're going to retake the testimony. To me, a de novo review, we're going to retake the testimony.
Retaking testimony isn't part of de novo review. You don't have to. You can just look at it again. It's a review. It's not a retrial. I'm just asking for a de novo review. So I don't want you to defer to anybody's credibility findings. I want you to just read that transcript. If there's a video, I want you to watch it. I want you to draw your own conclusions. Isn't that different than what you're suggesting?
Well, I guess it's how I look at de novo review. What they want is a de novo hearing. They want a new hearing, a new administrative law judge, a new chance to read.
Okay, but what's your best argument or your best authority for saying it doesn't, you can defer to what the original judge said? All we're talking about is assume you can have a new judge do it, but the level of review has to be completely de novo. You're not you're not deferring it to any degree.
And maybe I'm not understanding it, but let me put it this way then. I think you have to read 942 and 943 together. And I think that's just what the Arizona Appellate Handbook 2.0 did. You were a co-chair to that committee, and as I recall, you were an editor to the Arizona Appellate Handbook 2.0, and it states in Chapter 17, page 9, and I quote, "When a request for review has been filed, the administrative law judge who had issued the award, or, under exceptional circumstances, a substitute ALJ reviews the findings and award and enters a decision." And that's essentially what we have here. So I guess...
But that's not hold on. That's not an ministerial act. It's not an ministerial act. The reviewing judge has to look at the arguments and the facts presented and make its independent determination on the merits. And that's not what happened here, the way I read Judge Bodie's comments. She says, I'm bound by credibility determinations and I don't give a de novo review.
In regards to the credibility determination, that's what she said, but she also said that she reviewed the file in its entirety, and exactly...
She reviewed the file, but then she said she deferred to any findings made by Judge Sheo.
On the credibility, I believe it was.
And
I guess I look at it to follow up what you had asked earlier is in regards to credibility. I don't see credibility as that important in this case or a big deal because McDermott concedes he didn't forthwith report that injury. If you read his testimony, he testified he did not report it to his supervisor who was standing next to him when the injury happened.
Does it have to be immediately after? So I get injured, or maybe I don't even know I'm injured, or I don't know that I'm injured maybe slightly, and I went to karate yesterday, and I was feeling great after the session, and I woke up this morning and my back kills me. So, are you telling me that in order for that to count as an injury, in the moment when I'm feeling great, I have to turn to the instructor and say, "Oh, my back is injured"?
No, it does not. Forthwith reporting is a slippery slope, and it depends on the facts and circumstances.
Isn't it a mixed question? It's a mixed question of law and fact.
I would agree with that.
Okay, so let's start with, there was a workers' comp claim that was actually filed claiming injury within, 10 days?
Yes?
All right, so somewhere in that 10-day window, we have to determine whether or not the employee alerted the employer of a potential injury, correct?
Correct.
And didn't they say in didn't the employees say that Mr. McDermott indicated he wasn't sure of whether or not he was hurt on the job within just a day?
I think that's on the third day, Your Honor, yes.
On the third day. So you're saying that we're starting at a 10-day window, and we're saying in the first few days, he alerts the employer that he may have been injured, and that's not forthwith?
Well, it depends again on the facts and circumstances, as you said. He testified that he injures his knee. He steps down on the lift and he feels a pop and severe pain on the date of injury. He is right next to his supervisor, doesn't mention it. He then goes back to the yard, and at the yard with his supervisor, and the supervisor's supervisor again doesn't mention it. He's having symptoms when he leaves that day. Comes back the next day, has another incident the next day. By the end of the next day, he knows he's injured. He's going to seek medical treatment.
Can I take you back a step, though? I don't know that is there a requirement that it has to be sooner than 10 days? Why isn't 10 days forthwith? Let's say he didn't put anybody on notice, but he tells them 10 days later. Don't you at least have to then say, has the employer been prejudiced in some way? Let's say the first time he reports it, 10 days later, I've been out, I've been sore, I wasn't sure what happened, but I now firmly believe that I was injured 10 days ago. Are you saying that would not be forthwith reporting?
Well, again, it depends on the facts and circumstances, and forthwith reporting is that slippery slope. It can mean immediately, it can mean in a year.
And what do you do with the part of the equation that says, has the employer been prejudiced? Was there any prejudice here to the employer by whatever length of time it was before they realized he was making some sort of claim?
Well, I think the prejudice is that you leave work and we don't know what you do at home. You leave work after the first day.
In this case, if he'd reported it 2 days afterwards, and he files a former claim 2 days after, he's already left work, they don't know, something could have happened at home. Are you saying that's not forthwith reporting? If they find out 2 days after he says it happened?
Well, I would say if he reports it before he leaves work.
I'm saying he didn't report it before he left work, but 2 days later, he realizes it, and he reports it. That's not forthwith reporting?
I'm going to say it's in this situation, it's not. Under the facts and circumstances of this case, it is not.
So you would disagree with any kind of suggestion that sometimes pain develops a little bit later? You might not immediately, example Judge Faruya gave, you might not know exactly, and you get home and it hurts. You didn't report it before leaving. So under your definition, you could never forthwith report unless you reported before you left work?
No, I think, again, it depends on the facts and circumstances of the case. But in this situation, he testified. He stepped down, he heard it, he felt a pop, he had pain. He had pain when he left work that day. The second day he's there, he once again injures his knee, and he has pain. So he knows he has pain, he knows it's from work, he leaves work without reporting it. In this facts, in this circumstance, yes, I think that's...
I thought he was saying that I wasn't sure it was anything serious or anything I needed to worry about. Isn't that, so he twisted his knee and he thought, oh, that hurts. He immediately has to go in and tell his employer, I twisted my knee and I think it hurts. Or does he have to just simply wait and to determine if in fact it is it's a real thing? As in 2 days later when he realizes it's not going away and he's seeking medical care?
Well, that's the dilemma we all face here, Your Honor, and I would say under the facts and circumstances of this case, when he had an incident happen stepping on the lift on day 1, when he has a second incident happen getting out of his van on day 2, and he's got pain after both of those and knows he's going to go and seek medical treatment. It's day 2 when he decides to seek medical treatment. I think when you're at the point that you need medical treatment, you should report the injury.
Counsel, didn't he testify that he went home and he iced it and he put heat on it? I mean, isn't that medical treatment? Isn't he applying the medical treatment that was reasonable for what he perceived his pain was?
I mean, I know he went home and I know he said that he did something like that. I think that's a demonstration that you know something's wrong, you know you're injured at work, you know what happened at work, and you should probably report it to your employer.
Well, and what we're talking about here is injuries sufficient in order to make a claim, right? I mean, you wouldn't say that anybody gets a claim just because they get a bruise, right?
True.
Okay, so if I get a bruise and I know it's a bruise and I don't treat that as anything serious, but then it develops into a clot and then now all of a sudden I've got, an embolism, am I out of luck because I didn't forthwith report the bruise?
No, I think, again, it goes to the facts and circumstances of the case. An embolism is a far different situation than a knee injury. A knee injury, you're going to have pain typically. The chief amount of pain is going to be shortly after the injury, within a day or 2. So an embolism is going to take time to develop.
So he reports 3 days later, or 2 days later, but that's not forthwith.
Well, in this situation, no, I don't think it is, and I think that...
But again, I'm going to go back to what Judge Catani asked you. Where is your client prejudiced? Within 2 days, he is alerting the employer that he may have had an injury at work. What more was your client prejudiced? I mean, how is your client prejudiced?
Did you make that argument before Judge Sheo? Did they say we were prejudiced in some way?
I'm trying to think back to that. I can't really specifically answer that question, but the prejudice would be that we don't know what you did when you went home. We don't know what you did when you went home the second day. We don't know what you did when you went home the third day. So there's prejudice there. If you tell us immediately, now you haven't left work, you haven't left our premises.
Well, so I'm hearing you're saying there has to be there's an immediacy requirement. Boy, you have to alert us the minute it happens, because if you don't, then you're not going to get a workers' comp claim.
Well, no, that's not the law. It's based on...
It's not the law. Oh, great. Okay, so we're saying, is 2 days reasonable?
Depends on the facts and circumstances of the case, and in this case, I'm going to tell you, no, I don't believe it is. It's 3 days that he reports it.
But I don't see any testimony in there that says that, so you get access to the petitioner, and you're asking him on this, under oath what it is that he does in the time that's off, and he's telling you this on the record. For instance, after the first day, the answer was that he heated and iced his knee. There isn't any report of other injuries. So counsel develops that, and you develop that during testimony. So why weren't there any other questions about what prejudice there was?
Well, the other thing I think you have to take into account is prejudice is not the sole factor in regards to excusing a late request for a late reporting of the injury.
But I understand that, but set that aside for now, because you're talking about necessary versus sufficient, right? But what is it in this record that says on these facts, on these circumstances, that there's evidence in the record that your client was prejudiced by the passage of those 3 days?
Well, I'm going to go back to the fact that if you report this injury before you leave, we can take you right to a doctor. We know you haven't been off the premises. We know you haven't been doing something else.
I'm not talking about hypotheticals. I'm talking about what's in the record that he did in between that your client can point to and say, that exacerbated. That's the true cause of the injury.
Well, we would only have that information from him, and we do not have that. He did not testify as to anything that he did in between it.
Did you ask him that during his testimony?
I'm sure I did. I'm sure I did, definitely at the deposition.
And I understand your argument that, we could have sought immediate medical care, but there's no evidence in the record that there was a delay in medical care which exacerbated the injury, correct?
I believe that's correct, Your Honor.
Okay, so we're not looking, when we're talking about prejudice, it's the inability of the employer to investigate, to determine if in fact it was a work-related injury. And the second would be the delay in medical care that exacerbated the nature of the injury. And you have neither in this case.
I disagree. I think we have the fact that he leaves the premises without telling us what happened.
I think we've got your argument on this. I'd like to hear your analysis of the statutory language, and if we were to go down the road of spelling out whether it's okay to have a substitute judge, what's your best authority for us saying it is okay if an administrative law judge dies to have a new judge take it without vacating the ruling below?
Well, let me start by saying it's not uncommon for administrative law judges to tell us that they're retiring and continue to hear cases and issue decisions right up to the date they retire. And quite frankly, Judge Sheo's retirement was a well-known fact. Judge Sheo talked about this between hearings. I went back and listened to the hearings to see if he said anything on the record, and I couldn't find anything on the record.
What do you make of the statutory language?
All right, the statutory language, well, I think that you've got to read 942 and 943 together. 942, when you look at that statute, which specifically talks about awards, it specifically contemplates retirement or resignation of a judge. You look at 943, and it says presiding administrative law judge. Now you look at Koval. Koval's the case where it says presiding administrative law judge says it's the judge that heard the case. Now, if you look at that, that's 1975. If you read their decision, it talks about hearing officer. We don't have hearing officers anymore. We have administrative law judges. Back then in 1975, on review, the case was reviewed by the commission, the commissioners and the chief administrative law judge, not the judge who heard the case. So I think you have to look at it in the context of that. And in that situation, we've got 942 and 943. And I think the appellate, it's the Arizona Appellate Handbook, and that committee looked at this. And they specifically read those two together, and that's what they found on Chapter 17, page 9.
Do you agree that that's not binding authority on us?
Understood, but it's common sense. And it talks about exceptional circumstances, and I think this is an exceptional circumstance.
But don't you find it problematic that the reviewing, even if I agree with your argument that we have to use common sense and Judge Bodie could handle the review, given how she, and it is a she, correct?
Correct.
Given how she interpreted her role, she didn't do any type of assessment of the facts or the law. She just said, I have to defer to him, basically on the conclusion that he reached.
I guess I read it as she deferred to him on any credibility questions, but she reviewed the case. I mean, as I looked at her decision and the language she used upon review of the totality of the evidence, I can't remember the specific wording, she entered her decision upon review. So I know Judge Bodie. I think Judge Bodie's an excellent judge, and I think Judge Bodie, she stated that she reviewed the record, and that's what they're entitled to. So I think that we're pushing the bounds of review. Review is not meant for a de novo, and this is my term of de novo. It's not meant for a de novo, we start all over. We relitigate the issue.
But would you agree it's much like a motion to reconsider?
I would agree.
And a motion to reconsider, you're asking the same judge to, you got this wrong, including your credibility assessments. Well, you're not limited in a motion to reconsider. You can't say, I want to retry the case. But everything else is fair game in a motion to reconsider. Would you agree with that?
Yes.
So if we're just saying the reviewing judge, if it's a different judge, needs to do the same level of review that a judge would have to do in addressing a motion to reconsider, would you agree with that?
And I'm sorry, I didn't follow you. Could you say that one more time, please?
That a reviewing judge in this context has to conduct the same type of review that would be conducted in response to a motion to reconsider. You're not limited by anything. You're reconsidering what you've previously decided. If you're the judge, if you're someone else, you're reconsidering based on the facts and the evidence. You get to redecide. You don't have to defer to the first judge that heard it.
I think that's true.
Okay.
I think that's true. A couple of other things I just wanted to point out, if I may, if I've got time. I have very little time, but we talked about 4 cases: Kruger, Koval, Adams, and Brooks. These were all cases where a substitute judge was doing a decision upon review. So it's not completely unheard of. It's not uncommon. I think you have to read 23-942 with 23-943 and do the common sense analysis and look at it from, this was an exceptional circumstance. And under the circumstances, I don't believe McDermott's been deprived of his right to his day in court, nor has he been deprived of his right to a request for review. And on that basis, I request that you affirm the Commission's award.
Thank you, Mr. Kerr.
Thank you.
Very quickly, Mr. Bowman.
I have 12 seconds. The only point I'll make is that, based upon this court's questioning, it's obvious that there was a lot of evidence in this case. There's a lot of different conclusions that can be made from it, which is why request for review is a situation where the presiding judge revisits the evidence, revisits the stop process, revisits the law. So, that's why there's a distinction between 942 and 943. So, and just briefly, with respect to Koval, there's a cite that I made in my brief where it indicates that decision was made relative to the change in the statute after it went from the ICA doing the review to the judge doing the review.
And no question of unavailability in there.
Yeah. So thank you for taking our arguments today.
Thank you both for your arguments. We will take this matter under advisement and issue our decision in due course, and the court is adjourned.